A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. I'm glad you joined us on this Thursday, September 29th, the last Cam and Company of the week. But we will be, of course, updating bearingarms.com all day Friday throughout the weekend as well, just to make sure that you are up to date on all of the news you need to know about. And there's a lot of stuff going on. There's a hearing in Syracuse, New York today in federal court, taking on New York's new sensitive places restrictions, as well as some of the other concealed carry laws put in place in the wake of the Supreme Court's decision, New York State Rifle and Pistol Association versus Bruin. Now, this particular hearing is before a federal judge who has already said that many of these new provisions are unconstitutional. It was just that the folks who sued did not have standing to do so. So, Gun Owners of America have revised their complaint. They have some additional plaintiffs, and they believe that they do have standing now. I hesitate to even bring up this hearing because there's a slim chance that the judge could actually issue a ruling today, and what I just said might be a little out of date by the time you see this, but I expect that it will probably be Friday, maybe even Monday or some part of early next week before we get a decision from the federal judge as to whether or not this new request for a restraining order blocking the enforcement of some of these provisions in New York's new laws will in fact be granted. But in the meantime, we know that blue states around the country are looking at New York as the model legislation, basically, for their own post-Bruin restrictions. From California to New Jersey, as a matter of fact, we are seeing almost identical language being introduced in state legislatures, or plans to introduce identical language in state legislatures. From Hawaii, a Bill 220, was introduced this week by one of the Hawaii County Commissioners. Now, this is not a state-level bill. This is a county council bill. So this would apply for all of Hawaii County. Introduced by Hilo Councilmember Aaron Chung, it would amend Hawaii County Code to add an article related to licenses to carry both concealed and unconcealed firearms. This was apparently put in place at the request of the former police chief there in Hawaii County. And the new provisions are pretty extensive. Chung says, quote, they, meaning the Supreme Court, opened the door. They validated the idea that you can restrict having concealed weapons in certain areas, but they didn't specify where those sensitive areas would be. And so Aaron Chung said, well, since they opened the door, let's just burst it wide open here and shove as much crap through as possible. The Supreme Court did not lay out an exhaustive list of sensitive places. However, the Supreme Court's decision in Bruin made it very clear that we're talking about a general right to carry arms in public for the purposes of self-defense, a general right to carry in public, right? And some of the locations that they mentioned, specifically, they mentioned schools, they mentioned polling places, legislative assemblies. Those were the three places that they mentioned. Everybody seems to agree, okay, fine, those are sensitive places. But when you're talking again about a general right to carry, as the Supreme Court made clear, the bigger the list of sensitive places, the more likely it is that you are infringing on that general right to carry. And the Supreme Court warned the state of New York, for example, against declaring the entire island of Manhattan a gun-free zone. Well, New York hasn't declared the entirety of Manhattan to be a gun-free zone, but they have declared Times Square to be a gun-free zone. They have declared virtually all private property to be a gun-free zone, most publicly accessible places to be gun-free zones as well. In fact, when New York Governor Kathy Hochul was asked while these new bills were being debated, well, not even debated, rushed through the legislature, I think is a better way to describe it, where folks would be able to carry under the new rules, she kind of smirked and said, well, maybe some city streets. And she's basically right. That is, in essence, what's allowed under the new rules in New York, which is why I believe they're going to be struck down. Because, again, when we're talking about a general right to do something, New York has instead introduced general prohibitions. And there are only narrow exceptions to what is, in essence, a statewide ban on concealed carry. Hawaii, this bill that dropped in Hawaii County, not much different. Hospitals, medical facilities, medical offices, and or medical clinics would be gun-free zones, as would schools, colleges, universities, and or other places where persons are assembled for educational, literary, or scientific purposes. Yeah, again, you can already see the expansion, right? Well, the Supreme Court said that schools are okay. So why don't we just say that anything that can have an educational function or a literary function or a scientific function, therefore is like a school, and guns could be banned. Daycare centers, playgrounds, parks, and or other places where children gather. That's right. How dare you as a mom or dad want to protect your kid? Not allowed to, apparently, even in a public park. Any churches or religious assemblies. Again, doesn't matter if you as a pastor or a rabbi or a mom want to have armed parishioners, perhaps to serve as church security. Under this bill in Hawaii, you wouldn't be able to. Not allowed. Voter service centers or places of deposit. And any appurtenances, I've never seen that. I've never had to pronounce that word before. Appurtenances there too, as defined by Section 11.1 of the Hawaii Revised Statute. And places where people are assembled for an event, social gathering, rally, demonstration, or public exhibition that requires the issuance of a permit. Yeah. Along with, by the way, government buildings, courthouses, judiciary buildings, and the accompanying parking lots attached to such buildings, and a private property ban, right? Basically, all private property that's open to the public, where it is not conspicuously posted that the public carry of firearms is allowed. So again, a de facto ban on concealed carry on all private property. Some of these no-go zones for gun owners that Hawaii County wants to put in place have been challenged in other parts of the country since Bruin. And I should note, have been successfully challenged. There was a case just this week that was brought by Gun Owners of America and the Virginia Citizens Defense League. They sued the city of Winchester over some of its local gun-free zones put in place after the state legislature in Virginia weakened the state's firearm preemption law back in 2020. And a judge ruled that the ban on concealed carry during permitted events and in parks was, in fact, a violation of the Virginia state constitution. Held in place bans on carrying in rec centers and other government buildings. So it wasn't a total win for Second Amendment advocates, but we did get at least some of those ordinances halted from being enforced anyway. And again, some of those same provisions are in place in Hawaii. Now, the primary argument that was used in Virginia was the Virginia state constitution, but I would argue, and there are a lot of other sharp legal minds that are sharper than mine, like Dave Kopel, research director of the Independence Institute, who have warned Colorado municipalities that things like bans on guns in parks probably aren't going to fly. A park is not a sensitive place just because the public gathers there, just because there might be kids playing there. If there's no additional screening, if there aren't any metal detectors, if there aren't police, officers stationed there, if there's no evidence that the county government of Hawaii County considers parks to be so sensitive that people there are in need of extra protection that must be supplied by the state, well, it's really hard to argue that it's legitimately a sensitive place. As for the de facto private property bans, we are seeing this elsewhere as well. New Jersey Governor Phil Murphy says that a new bill adding to the list of gun-free zones in New Jersey is, quote, imminent and, yes, will include private property restrictions. He was speaking on the Ask the Governor program this week and said that churches, entertainment venues, and private property, quote, unless you, the homeowner, explicitly says otherwise, would be designated as gun-free zones under this proposed bill, which he says is coming within a month or two. Okay, we'll see. I have no doubt that we will see anti-gun legislation in New Jersey. The question is, if anti-gun Democrats in New Jersey wait a couple of months, what is the legal landscape going to look like in terms of these sensitive spaces? Because these gun-free zones, again, are being challenged in court, and I don't think many of them are going to stand. I do get, by the way, why the gun control groups are doing this. As Aaron Chung, that county council member in Hawaii, said, well, the Supreme Court opened the door for this by declining to list an exhaustive number of quote unquote sensitive places. The Supreme Court did, in a way, open the door for this abuse of the Bruen decision by anti-gun politicians. However, these anti-gun politicians are also still clearly abusing what the Supreme Court had to say, because, as I mentioned, the court made it clear that an exhaustive and expansive list of gun-free zones was not going to withstand constitutional scrutiny. You know, the test that was laid out by the Supreme Court in the Bruen case basically tells governments that they have to be able to justify these bans, not based on any cockamamie theory that, if we prevent people from protecting themselves, somehow that's going to lead to less violent crime. Instead, they have to look towards the text of the Second Amendment. They have to look towards the history of the right to keep and bear arms in this country. And unless they can find some sort of historical analog, particularly at the time of the founding or the ratification of the 14th Amendment to the gun control law that they are either defending or the gun control law they want to put on the books, that law is presumptively unconstitutional. And you simply don't have these types of broad, again, incredibly expansive areas where the exercise of a constitutionally protected right is off limits. You can't find it. There might be an outlier here or there, some town that passed a ban on carrying firearms in most areas, maybe had it on the books for a year or two. But by and large, that is not what the tradition of the right to keep and bear arms in this country looks like. And I think it's going to be very, very difficult for these anti-gun lawmakers to justify these expansive number of gun-free zones. But first test is in New York, and hopefully we will soon see again whether or not these gun laws will stand or fall, or at least, at the very least, be put on hold while the case is being litigated in federal court. All right, let's turn our attention now to today's armed citizen story, our good deed of the day, and our recidivist report. We'll start there. 6th time was the charm for a man in Mobile, Alabama, who is spending the rest of his life in prison now after convicted of shooting a convenience store clerk. It was his 6th felony offense, and that means that he has run out of chances, apparently. WALA reports that the life sentence without the possibility of parole was automatic because the defendant's 5 prior felony convictions tagged him as a habitual offender. And that includes, by the way, murder just a decade ago. 2013, this guy, Reginald Blevins, was convicted in the shooting death of a guy named Joey O'Brien. He was sentenced to 17 years in 2013, but he was already out on probation for murder when he shot and killed a clerk at a gas station in Mobile back in January of 2020. After that shooting, and he was arrested, a judge revoked his probation on that previous murder charge. But again, first of all, 17 years for murder doesn't sound like a lot to me. But when the murder happened in 2013, and by January of 2020, the convicted killer is already out on probation, what the heck is going on in Alabama? Now, again, we see these stories in red states and blue states. This is not just an Alabama problem. But if I lived in the state of Alabama, I'd be raising holy hell right now with my lawmakers asking, what's the deal where convicted killers get to get out of prison after less than 10 years? How's that working? Can we change that? The 36-year-old Blevins pleaded guilty in 2017 to the murder of Joey O'Brien. The victim's sister said that her brother was in the wrong place at the wrong time, riding his bicycle, and when he was shot. In addition to that murder, Blevins' rap sheet includes 4 other convictions: guilty pleas in 2015 to second-degree assault, shooting into an occupied vehicle, and third-degree robbery, as well as a 2014 guilty plea to possession of drugs. By the way, it gets even worse. I just realized it got even worse as I'm reading this story. The murder of Joey O'Brien happened in 2013. But Blevins didn't plead guilty until 2017 and was given a 17-year sentence. But by January of 2020, he was already on parole or on probation. So he did what? Less than 3 years for murder before he was released on the streets? Again, that's just staggering to me. But rather than trying to impose new gun control laws in Alabama, maybe they need to tighten up the criminal control laws instead. Just an idea. Today's armed citizen story from Alton, Illinois, where a man has been acquitted in a fatal shooting by a judge. Yeah, this was a case that actually went to trial. And a judge earlier this week ruled that 46-year-old Arvin Freeman was justified in shooting 30-year-old Robert Woods back on February 13th, 2021. Woods passed away as a result of the injuries. Judge Neil Schroeder said that a person is justified in using deadly force if they believe that it is necessary to prevent an attack on their home. The judge says the homeowner does not have to wait until the attack occurs to apply deadly force. And the judge went on to note that Arvin Freeman legally owned the gun that he used to fire at Woods. He noted that contrary to the state's version of events that day, Freeman shot Woods in the side of his butt. At a bench trial, a doctor testified that the bullet that killed Woods traveled from right to left in Woods' buttocks, hitting an artery and causing the fatal bleeding. This was a bench trial, so this wasn't a jury trial. It was the judge deciding whether or not Mr. Freeman was going to be found guilty of murder or acquitted. And the judge said that there were multiple occasions, including the day of the shooting, but also before the day of the shooting, where Woods had gone to Freeman's home and had caused a disturbance. In fact, the judge noted that on the day of the shooting, Woods had specifically told Freeman, "I'm going to kill you." The judge said that Woods was running away and turned while taking something out of his pocket, which Freeman believed was a gun. The judge said it didn't matter if what Woods retrieved was a gun or not. At that point, Freeman was in justifiable fear for his life and his property. Defense attorney Brian Polinsky says everybody has a right to protect their home, and this is a perfect example of that. It was a very scary situation. He said that he also went on to say the state's attorney is opposed to gun control, so therefore he should not oppose this decision. I mean, I don't know. That's throwing a little bit of shade at the prosecutor. The prosecutor, by the way, did say that the right of self-defense, quote, is a bedrock value of this office in our community. But he went on to say some cases involve a very difficult mix of facts and circumstances that make a determination on the applicability of such rights difficult. This was one such case. He said, fundamentally, due to its complexity and since a life was taken, we thought it important that a court hear and weigh all the evidence and testimony. The prosecutor added that we are disappointed in the outcome. We respect the determination of the court. All right, so there you go. Arvin Freeman, originally charged with murder. Case goes to trial, and a judge says, no, this was self-defense, and now this Illinois homeowner is hopefully back at home. Today's good deed of the day. Actually, we've got an update for you on yesterday's good deed of the day. This burning vehicle in Dallas, Texas, where an off-duty officer was in the right place at the right time and able to pull a woman out before the truck became fully engulfed. Apparently wasn't an off-duty officer. Somebody who was dressed in like security-type clothing, but the Dallas Police Department says, nope, not one of our officers. It was originally reported it was an off-duty cop who just happened to stop. Now nobody knows who it was. So if you know who that anonymous Good Samaritan in Dallas was, I'm sure that the person who was saved would love to know so they could say thanks. But today's good deed of the day, in the right place at the right time, willing and able to do the right thing. A police officer in Willard, Missouri, who saved the life of a newborn baby. Taylor Burt and Ray Daughtery's baby Asher was born last month, back on August 12th. And Taylor Burt was not able to make it to the hospital before little baby Asher arrived. It was a complicated delivery. And when Asher came into the world, he wasn't breathing. Police Sergeant Steve Purdy was the first officer to respond to the scene. When he got there, the mom was already doing CPR on Asher, but the baby was not responding. So Steve Purdy took over. Actually used a little infant CPR mask, hoping that it would help. A couple minutes go by, Asher's still not breathing, so the situation is getting incredibly serious at this point. But eventually, Sergeant Purdy was able to clear the baby's airway, and Asher started breathing. Steve Purdy said when the baby was breathing on its own, and I was able to hand the baby to its mom, that was much relief. Asher's parents, meanwhile, say if it wasn't for him, Sergeant Steve Purdy, and the other guys that showed up who were there, I definitely think it could have gone a lot worse than it did. So baby Asher is now about 6 weeks old and doing just fine. Sergeant Steve Purdy, he's a little bit older than 6 weeks old, but he is still on the job, doing good things for the folks here in Willard, Missouri, and we appreciate his life-saving efforts, again, in the right place at the right time, willing and able to do the right thing. Sergeant Purdy, we thank you for your very, very good deed. Now, that is about all the time we've got for you on this edition of Bearing Arms Cam & Company. Again, I will remind you to be checking out the website throughout the weekend because we do have a lot of stuff going on. We've got new lawsuits that are being filed by the day, both by Second Amendment organizations and by gun control groups, quite frankly. But we also have a number of court hearings, including the one in New York that I mentioned. That's going to be a big news, and we will keep it covered for you at bearingarms.com. If you like what you see, I would also encourage you to become a VIP member there at Bearing Arms. All you have to do, go to bearingarms.com/subscribe. Use the promo code GUNRIGHTS, and you can get a significant savings on your VIP membership. And as our way of saying thanks for showing your support, we're going to give you exclusive content, news stories, and analysis that you won't find anywhere else, because your support does matter, and it really does make a difference. So thank you again. We'll be back with another edition of Bearing Arms Cam & Company on Monday. We're going to be talking next week as well with Alan Gottlieb of the Second Amendment Foundation. They have the Gun Rights Policy Conference going on this weekend in Dallas, Texas. I am bummed that I'm not going to be able to make it there in person this year, but Alan is going to get us caught up on all of the great speakers and great events coming up in Dallas-Fort Worth this weekend. If you're able to attend GRPC, congratulations. Tell everybody I said hey. We'll see you again soon. Until then, be well, be safe, be free.